interpretation of contracts, it means the determination of the meaning of the terms or words used by the parties in their written contract. Article 1370. If the terms of a contract are clear and leave no doubt upon the intention of the contracting parties, the literal meaning of its stipulation shall control. If the words appear to be contrary to the evident intention of the parties, the latter shall prevail over the former. Explanation. When we say interpretation, it means the action of explaining the meaning of something. So when we say interpretation of contracts, it means the determination of the meaning of the terms or words used by the parties in their written contract. The words expressed or the stipulations of the said contract should be the one the parties are to fulfill with. In this case, the question is not what existed in the minds of the parties, but what intention is expressed in the language used. So, a contract was executed between Vince and Joe. The contract expressly stated that it is a sale of bag to Joe for 250 pesos. The contract described Vince as the vendor and Joe as the vendee. With the statement above, it is clearly a contract of sale. No other interpretation should be given which would alter or change the plain meaning of the word. It is a cardinal rule in the interpretation of contracts that if the terms of a contract are clear and leave no doubt upon the intention of the contracting parties, the literal meaning of its stipulations shall control. The court must not read into any other intention of the contracting parties contradictory to the plain meaning. To give you a clearer example towards this explanation, here is an example. Vince and Hannah enters a contract of sale which Vince is to sell his bag to Hannah for 2,000 pesos. The value of the said bag is 3,500, which it was appraised, then 4,500 on their final meeting. However, in their contract, it is stipulated that the purchase price is 3,000. Even though the amount of 3,000 is contrary to what is evident in the intention of the parties, the final shall prevail. Article 1371. In order to judge the intention of the contracting parties, their contemporaneous and subsequent acts shall be principally considered. When we say contemporaneous, this will occur in the same period of time, and the subsequent acts is the one which is following in time or order of the acts of the contracting parties. Note: this article only applies when the terms of the contract are ambiguous. So why are contemporaneous and subsequent acts relevant in the determination of intention? When a contract is ambiguous or cannot be clearly interpreted, the contemporaneous acts and subsequent acts may be considered by the court in determining its meaning and to make sure the intentions of the party. So, for example, Vince and Joe entered in a contract of lease in which Vince is the lessor and Joe is the lessee. Although it's a contract of lease, it is stated that Vince transferred the ownership of land to Joe. The title of the land was given by Vince to Joe, who registered the land to his name. Before the date of the contract, Vince wrote a letter to Joe offering to buy the land. By their acts, it is clearly evident that this is under a contract of sale and not on lease, since the evident intention is to make Joe the owner of the land.
Article 1372. However general the terms of a contract may be, they shall not be understood to comprehend things that are distinct and cases that are different from those upon which the parties intended to agree. The reason for this rule is that when the parties express themselves in reference to a particular matter, it must be assumed that it expresses their intent. For example, Sarah sold her house including all furnitures therein. The term all should not be understood to include Sarah's portable fridge, microwave, and ovens, as they are distinct and different from the word furniture. Article 1373. If some stipulation of any contract should admit of several meanings, it shall be understood as bearing that import which is most adequate to render it effectual. For example, Elijah sold his parcel of land to Betty. Elijah owns 3 lands, one owned by him absolutely, and the other 2 of which he shared ownership with his siblings. Elijah's siblings did not give their consent to the sale. It shall be understood that the sale should refer to the land owned by him alone, as this would make the contract effectual. Now, if one interpretation makes a contract valid and the other makes it illegal, the former interpretation is one which is warranted by the rules stated in this article. Article 1374. The various stipulations of a contract shall be interpreted together, attributing to the doubtful ones that sense which may result from all of them taken jointly. All provisions should, if possible, be so interpreted as to harmonize with each other. For example, Ramon leased his apartment to Wes. It was stated in the contract that if Wes subleased the apartment, it should be with the written consent of Ramon. If violated, Wes shall pay additional rent of 2,000 a month. If Wes subleased the apartment without the consent of Ramon, in the light of the clause stating the penalty for the violation of the condition, Ramon has no right to eject Wes.
Article 1375. Words which may have different significations shall be understood in that which is most in keeping with the nature and object of the contract. Words used in a contract which are susceptible to two or more meanings shall be understood to follow that meaning which is most in keeping with the nature and object of the agreement. For example, Romeo leased Elena a roof for the purpose of erecting an advertising sign. The contract provides for the termination of the lease by Elena if a building should be constructed on an adjoining property of such height and to obscure the view of Elena's sign. There was erected on the roof of an adjoining building a sign which obstructed the view of Elena's sign. In this case, the term building as the term used in the contract may be interpreted as to include the obstructing sign having in mind the nature and object of the contract. Article 1376. The usage or custom of the place shall be borne in mind in the interpretation of the ambiguities of a contract, and shall fill the omission of stipulations which are ordinarily established. This article talks about the effect of usage or custom of the place. The usage or custom of the place where the contract was entered may be received to explain what is doubtful or ambiguous in a contract on the theory that the parties entered into their contract with reference to such usage or custom. For example, Liza rendered services to Yana, but the contract did not provide for the amount of compensation to be paid. In this case, the amount must be determined by the rate customarily paid in the place where the services were rendered.
Article 1377. The interpretation of obscure words or stipulations in a contract shall not favor the party who has caused the obscurity. A written agreement should, in case of doubt or ambiguity, be interpreted strictly against the party who has drawn it, or be given an interpretation which will be favorable to the other who, upon the faith of which, has incurred an obligation, when justified in the light of the operative facts and surrounding circumstances. Thus, one who prepared the contract which states terms cash upon signing of this contract cannot deny that the agreement was a cash transaction. The reason for the rule in Article 1377 is that the party who drafted the contract more easily than the other could have prevented mistakes or ambiguity in meaning by careful choice of words or by the exercise of a little more care, and generally, the party who causes the obscurity acts with ulterior motives. Article 1377 is not applicable where the evident intention of the parties can be readily discerned by their contemporaneous and subsequent acts, and there is no indication that the party who prepared the contract took unfair advantage of the other party who freely assented to it, which is written entirely in a language spoken and understood by both parties. Article 1378. when it is absolutely impossible to settle doubts by the rules established in the preceding articles, and the doubts refer to incidental circumstances of a gratuitous contract, the least transmission of rights and interests shall prevail. If the contract is onerous, the doubt shall be settled in favor of the greatest reciprocity of interests. If the doubts are cast upon the principal object of the contract in such a way that it cannot be known what may have been the intention or will of the parties, the contract shall be null and void. When, despite the application of the preceding rules, certain doubts still exist, such doubts shall be resolved in accordance with the supplementary rules stated in the present article. 1. For a gratuitous contract, if the doubts refer to incidental circumstances of a gratuitous contract, such interpretation should be made which would result in the least transmission of rights and interests. For example, M gave his motorcycle to D. It is not clear whether the contract is a donation or a comodatum. The contract should be presumed as a mere comodatum because it would transmit less rights than a donation since M retains his ownership of the motorcycle. 2. For an onerous contract, if the contract in question is onerous, the doubts should be resolved in favor of the greatest reciprocity of interests. For example, M borrowed from D 25,000 at 10% interest. It cannot be determined from the terms of the contract whether the loan is payable in 8 months or in 1 year. It must be assumed that the period agreed upon is 1 year, which results in a greater reciprocity of interest since M can use the money for 1 year, and D, on the other hand, can earn interest due for 1 year instead of only 8 months. 3. If the doubt refers to the principal object of the contract, and such doubt cannot be resolved, thereby leaving the intention of the parties unknown, the contract shall be null and void. For example, M sold his car to D. M has many cars. It cannot be determined which car was intended by the parties to be the subject of the sale. Therefore, the contract shall be null and void, and it is as if the parties have not entered into any contract at all. Article 1379. The principles of interpretation stated in Rule 123 of the Rules of the Court shall likewise be observed in the construction of contracts. The rules in the Rules of Court on the interpretation of documents are now contained in Rule 130, sections 10 to 19. The rules may be summarized as follows. 1. The language of a writing shall have the legal meaning it bears in the place of execution, unless the parties intended otherwise. 2. An instrument with several provisions or particulars shall be construed so as to give effect to all. 3. In case of conflict between a general and a particular provision, the latter shall prevail. So a particular intent will control a general one that is inconsistent with it. 4. The circumstances under which the instrument was made, including the situation of the subject thereof and of the parties to it, may be considered in its interpretation. 5. Terms are presumed to have been used in their ordinary and generally accepted meaning unless intended to have been used in a different sense. 6. In case of conflict, the written words prevail over the printed form. 7. Experts and interpreters may be asked to declare the characters or the meaning of the language when such characters are difficult to decipher or the language is not understood by the court. 8. Of two constructions, that sense is to prevail against the party in which he understood it, or which is most favorable to the party in whose favor the provision was made. 9. Of those constructions, one in favor and the other against natural right, the former is to be adopted. And 10. Usage may be the basis to determine the true character of an instrument.
What is a rescissible contract? A rescissible contract is one which contains all the essential requisites of a contract which makes it valid, but by reasons of injury or damage to either of the contracting parties or to third person, such as creditors, it may be rescinded. Requisites of rescission: 1. The contract must be validly agreed upon. 2. There must be lesion or pecuniary prejudice or damage to one of the parties or to a third person. 3. The rescission must be based upon a case especially provided by law. 4. There must be no other legal remedy to obtain reparation for the damage. 5. The party asking for rescission must be able to return what he is obliged to restore by reason of the contract. 6. The object of the contract must not legally be in the possession of third persons who did not act in bad faith. And 7. The period for filing the action for rescission must not have prescribed. Article 1380. Contracts validly agreed upon may be rescinded in the cases established by law. Example: Kara sues Mia for the recovery of a parcel of land. In this case, the land is a thing under litigation. If during the pendency of the case, Mia sells the land to a third party without the approval of Kara or of the court, the sale is rescissible at the instance of Kara in case she wins in her suit for the recovery of said land unless the third party is in legal possession of the land in good faith. Article 1381. The following contracts are rescissible. 1. Those which are entered into by guardians whenever the wards whom they represent suffer lesion by more than 1/4 of the value of the things which are the object thereof. 2. Those agreed upon in representation of absentees, if the latter suffer the lesion stated in the preceding number. 3. Those undertaken in fraud of creditors when the latter cannot in any other manner collect the claims due them. 4. Those which refer to things under litigation if they have been entered into by the defendant without the knowledge and approval of the litigants or of competent judicial authority. 5. All other contracts specially declared by law to be subject to rescission. 1. Contracts entered into in behalf of wards. A ward is a person under guardianship by reason of some incapacity. As a rule, the powers of the guardian with respect to the property of the ward are limited to mere acts of administration. Example: Gina is the guardian of Wendell, the ward. Gina sells the property of Wendell worth 20 million for only 14 million. The contract of sale can be rescinded because the lesion is more than 1/4. Wendell can rescind the sale by proper action in court upon reaching the age of majority. 2. Contracts agreed upon in representation of absentees. An absentee is a person who disappears from his domicile, his whereabouts being unknown, and without leaving an agent to administer his property. Likewise, the absentee must suffer lesion by more than 1/4 of the value of the property object of the contract to entitle him to the remedy of rescission. Example: Wendell, the owner of a resort in Laguna, left his property without notice and without leaving a representative to take care of his property. Ben, a family friend, volunteered in taking over Wendell's business. Due to a storm, Wendell's business is greatly affected due to destruction of some of the buildings of the resort and needs additional funds to recover from such distress. Ben decided to sell one property of Wendell worth 15 million and sold it for only 10 million. When Wendell returned, Wendell can rescind the contract of sale made by Ben because the lesion is more than 1/4. It must be noted that paragraphs 1 and 2 refer only to transactions by guardians and absentees representatives. Rescission cannot take place if the contracts have been approved by the court. As a general rule, lesion does not invalidate a contract except only in special cases specified by law. 3. Contracts undertaken in fraud of creditors. The action to rescind in fraud of creditors is known as acción poliana. Here, the remedy of rescission may be availed of by a third person. Such contracts are usually made without the knowledge of the creditors. In order that fraud of creditors may be a valid ground for rescission, the following requisites must also be present. A. There must be an existing credit prior to the contract to be rescinded, although it is not yet due or demandable later. B. The subsequent contract made by the debtor conveys a patrimonial benefit to a third person. C. There must be fraud on the part of the debtor which may be presumed or proved. D. The creditor has no other legal remedy to satisfy his claim, that is, he cannot recover his credit in any other manner, it not being required that the debtor be insolvent. Example: Gina made a donation of a parcel of land to Wendell. Before the date of the donation, Gina had contracted several debts. With the donation to Wendell, the remaining property of Gina is not sufficient to pay all her debts. The donation can be rescinded because the alienation is presumed in fraud. 4. Contracts which refer to things under litigation. In number 3, the purpose of the remedy is to secure the payment of an existing credit of a third person against a party to a contract sought to be rescinded. Here, the purpose is to make effective the claim of a party litigant over a thing under litigation which was the object of a contract entered into by the other party with another person. The right to file the action for rescission arises in favor of the plaintiff when the defendant enters into a contract over the thing in litigation without the knowledge or approval of the plaintiff or the court. Example, Sandy sues Ben for the recovery of a parcel of land. In this case, the land is a thing under litigation. If, during the pendency of the case, Ben sells the land to Kathy without the approval of Sandy or of the court, the sale is rescissible at the instance of Sandy in case she wins in her suit for the recovery of said land unless Kathy is in legal possession of the land. In good faith. Sandy, however, may protect his right by filing a notice of lis pendens.
Article 1382. Payments made in the state of insolvency for obligation to whose fulfillment the debtor could not be compelled at the time they were affected are also rescissible. If one party is unable to pay debts owed, the injured party can rescind the contract. Rescission is only necessary in this article whenever one party is not qualified to pay the debt. What is insolvency? It is the incapacity of the debtor to pay the debts upon the date when they become due. Whenever a payment is in a state of insolvency, the debtor is considered insolvent if he does not have sufficient properties for him to fulfill his obligation. But it is not necessary that the debtor's insolvency is not judicially declared. Obligations included should be the ones that are due, demandable, and also obligations that cannot be legally demanded, such as natural obligations. For example, Dan loaned 5,000 pesos to Clark, which should be paid 3 months after. When the period has passed, Dan was still not able to comply with the required action for the obligation, which forced Clark to call for legal remedies towards Dan. Clark, the injured party, may select either to go on with the fulfillment of the obligation for it to be extinguished, or rescission, where Dan still has to pay for the debt. Article 1383. The action for rescission is subsidiary. It cannot be instituted except when the party suffering damage has no other legal means to obtain reparation for the same. In this article, rescission is not identified as a principal remedy, but instead is identified as a subsidiary remedy, which means the injured party may benefit from it if they could prove that they have no other legal means to obtain reparation of the damages suffered. Otherwise, they are not entitled for the rescission. Parties who are allowed to file for a rescission are parties who suffered economic lesion, the affected creditor, others authorized by the law.
Article 1384. Rescission shall only be to the extent necessary to cover damages caused. So the law's policy is to preserve the contract, not to extinguish it. So instead of rescinding a contract, damage reparation or partial rescission may be observed. Now, the extent of rescission must only be to the creditor's unsatisfied credit. For example, Sally had 2 parcels of land worth 250,000 pesos each, and her legal guardian, Andy, was authorized by the court to sell the aforementioned land. Andy sold 2 parcels of land to Mike for 250,000 pesos only. Can the entire contract be rescinded? Now the answer is no, it is not necessary. The application of rescission may only be applied to 1 parcel to cover for the damages caused by Andy. If Andy or Mike is willing to pay the difference of 250,000 pesos, the rescission is ruled out in advance. Article 1385. Rescission creates the obligation to return the things which were the object of the contract, together with their fruits, and the price with its interest. Consequently, it can be carried out only when he who demands rescission can return whatever he may be obliged to restore. Neither shall rescission take place when the things which are the object of the contract are legally in the possession of third persons who did not act in bad faith. In this case, indemnity for charges may be demanded from the person causing the loss. An obligation of mutual restitution takes place once the court declares rescission of the contract. The purpose here is to restore both parties into their original situation. The obligation of mutual restitution requires 1. To return the thing and its fruits, 2. To return the price thereof with legal interest. This is also applicable to the third persons who, in good faith, acquired the thing of the rescinded contract. However, the exceptions to this article are as follows. Number 1. The party who demands rescission cannot return what he is obliged to restore. The rescission will require that party to return the thing from his end of the contract. If he cannot do so, then rescission will not be allowed. Number 2. The property is in possession of a third person who acted in good faith. So in here, the third person is unaware of the flaws of the contract. The remedy here is to demand indemnity for the charges from the person who has caused the loss. For example, Allison, the legal guardian of Sharky, sold Sharky's land to Clara for 215,000 pesos instead of its true value worth 250,000 pesos. What can Sharky do? When Sharky reaches the age of maturity, he may ask for the rescission of the sale on the grounds of lesion. Upon the declaration of rescission, Clara must return the land with the fruits received by her, and Sharky must return the amount of 215,000 pesos plus the legal interest. Now let's say Clara sold the land to Bells, and Bells knew the flaws of the contract but continued the transaction anyways. What are the remedies for Sharky? Now Bells acted in bad faith, so Sharky may demand the land, or if it cannot be returned, Bells must be liable for the losses by returning the value of 250,000 pesos and the damages if warranted.
Article 1386. Rescission referred to in numbers 1 and 2 of Article 1381 shall not take place with respect to contracts approved by the courts. Contracts approved by the courts. These are contracts entered into by the guardian or representative where the ward or absentee suffers a lesion of more than one-fourth of the value of the property. If the contract is approved by the court, rescission cannot be availed even if lesion of more than one-fourth the value of the property be suffered by the ward or absentee. When a contract is entered in behalf of a ward for an act of ownership, the approval of the court is required. For example, Tom is the guardian of Jerry, a minor. Tom sells the 20,000 worth property of Jerry for only 15,000 pesos. Here, the contract of sale cannot be rescinded because the lesion is not more than one-fourth unless the contract of sale is approved by the court. However, if the property is sold for less than 15,000 pesos, Jerry can rescind the sale by proper action. Article 1387. All contracts by virtue of which the debtor alienates property by gratuitous title are presumed to have been entered into in fraud of creditors when the donor did not reserve sufficient property to pay all debts contracted before the donation. Alienation by onerous title are also presumed fraudulent when made by persons against whom some judgment has been issued. The decision or attachment need not refer to the property alienated and need not have been obtained by the party seeking the rescission. In addition to these presumptions, the design to defraud creditors may be proved in any other manner recognized by the law of evidence. Fraud presumed. The provision established prima facie presumptions of fraud in the case of alienation by the debtor of his property. However, the instances mentioned are not exclusive of others that may be proved in any other manner recognized by the law of evidence. Example of paragraph 1 of this article. Riri made a donation of a parcel of land to Edgar. Before the date of the donation, Riri had contracted several debts. With the donation to Edgar, the remaining property of Riri is not sufficient to pay all his debts. Under the first paragraph, the donation is presumed fraudulent unless proved otherwise. Alienation by onerous under paragraph 2 of this provision. The same example under paragraph 1 if the contract is a sale. Under the second paragraph, the sale to Edgar is not presumed fraudulent. The creditors of Riri must show that the conveyance will prejudice the rights. However, the presumption of fraud will arise in case the sale was made by Riri after some judgment has been issued against him. Suppose again that Chris, a creditor of Riri, has obtained a judgment or right of attachment in his favor. Then Riri sold to Dan another parcel of land which has not been levied upon or attached. The sale to Dan is also presumed fraudulent because the law says the rescission or attachment need not refer to the property alienated. Circumstances denominated as badge of fraud. The following are some of the circumstances attending sales which have been denominated by the courts as badges of fraud. First, the fact that the consideration of the conveyance is fictitious or inadequate. Second, a transfer made by a debtor after suit has been begun and while it is pending against him. Third, a sale upon credit by an insolvent debtor. Fourth, the transfer of all of his property by a debtor, especially when he is insolvent or greatly embarrassed financially. Fifth, the fact that the transfer is made between father and son when there are present some or any of the above circumstances. Sixth, the failure of the vendor to take exclusive possession of all property, and lastly, it was known to the vendee that the vendor had no properties other than that sold to him. Effect of fraud. Fraud is only one of the requisites for the action Pollyanna. The existence of fraud does not make the alienation rescissible, whether the fraud is presumed or proven. If the transferee acquired the thing in good faith and for valuable consideration, even if the debtor who made the alienation acts fraudulently, rescission will not be allowed.
Article 1388. Whoever acquires in bad faith the things alienated in fraud of creditors shall indemnify the latter for damages suffered by them on account of the alienation, whenever, due to any cause, it should be impossible for him to return them. If there are two or more alienations, the first acquirer shall be liable first, and so on successively. The purchaser of bad faith, who acquired the object of the contract alienated in fraud or creditors, must return the same if the sale is rescinded. Should it be impossible for him to return it, due to any cause, he must indemnify the former. And if there are two or more alienations, the first acquirer shall be liable first, and so on successively. Example: J convinced K, his friend, to buy his car pawned for 150,000 pesos. J was afraid that the pawn store will take possession of his car after he failed to pay his loan after it became overdue and demandable. K knew J's purpose and still bought the car. While the said car was parked in front of K's house, it was rammed by a pavement roller and was consequently damaged beyond repair. K, being a buyer in bad faith, shall indemnify the pawn store either for the amount of J's loan or the monetary value of the car in question. Article 1389. The action to claim rescission must be commenced within 4 years. For persons under guardianship and for absentees, The period of 4 years shall not begin until the termination of the former's incapacity or until the domicile of the latter is known. As a general rule, the action to claim rescission must be commenced within 4 years from the date the contract was entered into. The exceptions are: for persons under guardianship, the period shall begin from the termination of incapacity, and for absentees, from the time the domicile is known. The action for rescission may be brought by the injured party or the defrauded creditor, his heirs, assigns, or successors in interest, or the creditors of the above, entitled to subrogation. Example: Leah is the guardian of Bea, who is a minor. Leah sells the property of Bea worth 1 million pesos for only 700,000 pesos. Here, the contract of sale can be rescinded because the lesion is more than 1/4. It can be rescinded within 4 years at the time the incapacity ceases.